This is the current federal tax developments for the week of October the 17th, 2016. Current federal tax developments, as always, is brought to you by Nichols Patrick CPA Incorporated and your state society of CPAs. I'm Ed Zollers, and I'll be talking to you this week about some of the things that have happened recently in the area of federal taxes. Got to apologize quickly because due to the end of tax season, ended up with a lot of little returns to take care of here right at the end, a few other issues that popped up, and I was on the road quite a bit. So unfortunately, last week we had to delay the podcast. So we're going to talk this week about some of the developments that have occurred since we last got together. And I'm also going to warn you that I'm taking a look and probably going to look in more detail later this week at a couple of regulation projects the IRS issued. We won't talk about much about them this week, but the IRS did get out the debt equity regulations that have been much anticipated in the corporate realm, and also additional regulations on allocations of debt in partnerships and disguised sales. So I'll hopefully have some time to look at that as I fly across the country this week to get to Atlanta. So I have a chance to maybe write some stuff up and take a look at those regulations, but just wanted you to be aware those things are out there and coming up. Well, got a few times coming up now. We're now past, today, of course, today I'm recording this, which is the 17th, is the last day for individuals to file their returns timely. So we're now at the end of tax season. Hey, it finally ends. Because of that, we're now into the major league CPE season. And I wanted to remind you about some of our current federal tax developments presentations coming up here during the end of the year. We have scheduled coming up on November 1st in Akron, Ohio. Mark Patrick will be presenting a set, which will be the updates for the year. On November the 11th, I'll be presenting in Tucson, Arizona. Mark will be presenting in Youngtown. Mark will move on to Toledo on November the 18th. And on December the 16th, I'll be lecturing here in Phoenix again on the developments. We'll talk about what's gone on this year, what's important among the items we talked about this year, kind of try to pick out the highlights for the year, and also, take a look at maybe what might be happening or what we might learn or not learn after the elections for those of you who are taking any of these after the 8th. We'll discover what the election gives us, and probably we won't know a whole lot about what's really going to happen. Because until the Congress and the new president gets together, we're not sure exactly how everything's going to interact, but we might be able to discuss some things. At least we'll know which proposals are supposedly on the table and which ones now can be basically consigned to the dustbin of history, because losing candidates don't tend to get too much of their stuff into law in the future. So we'll take a look at, what might come up. With that, let's start this week's particular developments. We're going to start out with an IRS announcement where the IRS on September the 22nd had announced that they were going to force everybody who was using e-services to go through the secure access system that the IRS has for accessing information online. Now, we've discussed that program here before with relation to like the IRS transcript system, and we've discussed the additional steps the IRS is going to be forcing people to go through in order to prove that they're really them. Well, the IRS wanted to expand that to anybody who uses e-services, and they require you essentially to sign up and use this for any e-services provided items. That was to have been required effective a week from today on October the 24th. But last week on the 14th, last week, the IRS announced that, okay, maybe we won't go forward so quickly with this. What was the problem? A couple of problems come up. Number one, as we've discussed previously, this new system, we expect that a whole lot of people will be unable to prove their identity under the new system. Certainly, they won't be able to prove it online. Some things that would likely get in the way, especially for e-services, are going to be things like the fact that you have to have a cell phone in your personal name. If you have a company-issued cell phone, that's not going to count to prove you're you. Secondly, it's got to be, as I mentioned before, a postpaid cell phone. That's normally with one of the major carriers, which has gone through a credit check. If you have basically a prepaid plan, like you'd have from sometimes even the major carriers and from third-party services, that's not going to work for this purpose. In those cases, you'll now be required to effectively get yourself a code via mail, which will lock you out of the system, apparently, for a while until you get that code in. And the IRS also clearly admits that some people simply will never be able to answer the questions for the knowledge-based authentication that are going to be more difficult now. So because of that, they're going to set up special phone lines, was their theory, to allow you to call in, which we would expect to be swamped almost immediately. And even then, if they can't verify who you are on the phone, and I have a feeling they're going to try to verify that by asking you the same KBA questions you couldn't answer in the first place, then you may be forced to go down to a taxpayer assistance center somewhere, hopefully nearby you, and prove your identity. Oh, by the way, you'll be down there with all the taxpayers, and you'll be sitting there in line half a day waiting to show your IDs to the person to let yourself into the service. As a lot of people and professionals pointed out, they use this service regularly and daily. And the reality is they couldn't really afford to be down, especially not here at the end of October, and be unable to get into the system, which very well could happen to a number of people who might have to go through the more complicated systems of proving who they are. Well, because of that, the IRS has now announced that this secure access for e-services has been indefinitely delayed. They're not saying they're not going to do it. In fact, I suspect eventually they will. But what they are saying is they're not going to move forward right now. That seems to be the prudent step, given the fact that with the deadlines in question and giving people only effectively a month to get into the system, a month when they were kind of a little bit busy with other things going on, that probably wasn't the best timing in the world. Next up, we have Revenue Procedure 2016-53 and Regulation, which is proposed Reg 150992-13, both of which were issued on October 13th. This is a case where the IRS has now issued guidance on how you can elect to claim a disaster loss in a year prior to the federally declared disaster. Taxpayers who are impacted by that. Section 165I allows taxpayers in a presidentially declared, federal disaster area to elect to claim their losses on the tax return for the year before the year in which the disaster took place. So, for instance, for those who are affected by Hurricane Matthew in the areas that are federally designated disaster areas, those individuals can make an election to claim the casualty losses or claim the losses that they have rising from this disaster on their 2015 return. That's found in Section 165I. The revenue procedure outlines the steps to go ahead and make this election. Some key issues with this. First thing is the revenue procedure and the proposed regs set up some due dates. A taxpayer will have until 6 months after the unextended due date of the return for the year of the disaster. So, for instance, for an individual who was impacted by Hurricane Matthew, you're looking at basically October 15th of 2017, and that's regardless of whether or not they extend the return for 2017. They could make the election to throw it back onto 15. And then if you want to revoke the election and decide, no, I want to claim it the year of the disaster now, you have 90 days after that final due date for claiming it on the return. So you could theoretically claim it on your 2016 return, or I should say claim it on throw it back into 2016 to get money today. Then you might determine, or throw back to 15, you might determine when you finish the 16 return, you'd be better off then, so you can revoke it. If you do either, amend your prior return to claim the deduction, or you revoke a current deduction, and you previously filed a return claiming the loss on the other year, a requirement of the revenue procedure is that you must absolutely amend your return for the year in which you're no longer going to claim the loss and arrange to pay for any taxes due either before or at the same time as you file the amended return, the revised return, to change the treatment. The notice has information regarding what you have to attach to the return if you're going to make this election and how you do so. And again, the proposed regs obviously are out there for discussion at this point to try to implement that, but the revenue procedure will work for now. Clearly, with natural disasters take place all the time. Federally declared disaster areas arise from time to time. Most recently, as we've noted, in Hurricane Matthew. If you are involved, have clients who may be impacted by that, you want to take a look. Please remember, it does have to be a federally declared disaster area. This is not something that's allowed for all casualty losses. Next up, Action on Decision 2016-03, issued on October 2nd of this year. The Third Circuit Court of Appeals. This is the case of the Giant Eagle decision, and the IRS has announced they will not follow it. The Third Circuit had ruled that Giant Eagle, who is for those of you who are not aware, don't have them in your area, is a grocery chain, and they offer a program called Fuel Perks. What it is, you buy so many groceries at the store, and then you get discounts on buying gasoline. The question becomes, what about those unredeemed fuel perks that existed at the end of the taxpayer's year? Can Giant Eagle claim a deduction based on those based on the amount that they expect will be redeemed, or must they wait and claim the deduction in the following year? Well, the tax court had ruled that they had to wait till the following year. They had ruled that because there was this 3-month time period to redeem your fuel perks, and because a customer had actually buy gas in order to trigger the liability, that the transaction was not complete, and because of that, no accrued deduction could be allowed. The Third Circuit did not agree. Now, the Third Circuit, as you may go, if you go look back at this case when it was first issued, the Third Circuit made it a point that, the tax court thought it was a big deal that these things expired. And we had previous cases where a reward never expired, where the deduction was allowed. The Third Circuit did not find that significant. Now, the IRS has now come out and said, effectively, we're not going to follow the Third Circuit. Well, we should modify that. They will follow the Third Circuit decision, obviously, in the Third Circuit, because we're going to get that same result there. But for those of you who do not have your appeals go to the Third Circuit, the IRS is not going to follow this. So if it gets raised, like for me here in Arizona, the IRS, if we had a situation like that with some sort of reward program or something else that could be redeemed, but there'd be a time limit on it, but we could still predict it with high accuracy. The reality is we're not going to be able to claim that deduction per the IRS. You have to be willing to go to the tax court, who, by the way, remember, ruled against Giant Eagle, and that's a published decision of the tax court, which we would assume they'd follow. So here I'd be telling a taxpayer we probably have to go all the way to the Ninth Circuit if challenged in order to be able to win this. And we don't know if we'd win or not. The question is, do you want to be the taxpayer to figure that one out? Next up, the case of the Harvey C. Hubbell Trust versus Commissioner. Tax Court Summary Opinion 2016-67, issued on October 13th. Now, this is a case of a trust that had been around quite a while. This trust had been making charitable contributions, and very significant charitable contributions, ever since 1985. In fact, in 85, it made a contribution of over $300,000. This trust had been established by the will of Mr. Hubbell, and this will had provided that the trust would essentially pay annuities to a number of beneficiaries for their life. And the trust provided that was the only authorized payment for their life. But after the last beneficiary died, the trust would either terminate, or it could be run for an additional 10 years. But the trustees were to distribute the funds in such a way that would be deductible for both Ohio and federal estate tax purposes. Now, the problem had been, of course, that under Section 642, a trust can only claim a charitable contribution deduction if the contribution is made pursuant to the terms of the trust. The IRS claimed that this was not pursuant to any terms of the trust, therefore they disallowed the 2009 deduction. Obviously, the service's position would have been that the deductions in prior years also probably should have been disallowed, but those weren't under exam and most were closed. Probably most, or I would assume by the time this all got finished, all were closed. So the taxpayer goes to court and says, no. Okay, we understand we have no terms in the trust that says was authorized because the beneficiaries are still alive. So it said, we know we don't have that, but we think there is basically an ambiguity in the trust. And look, the attorney had been involved with the trust for years who drafted it and talked with Mr. Hubbell. It's clear that Mr. Hubbell's intent was to allow the trust to make charitable contributions. And so because of that, we think our deduction is allowed even before we got to that point after the last beneficiary had died. Well, the tax court said, there's no ambiguity in the terms of this trust. In fact, it pointed out that, we knew all along by then how to write a trust to allow for charitable contributions. This trust never made such an allowance and, in fact, appeared to prohibit it. The fact that it actually done so, and even with the attorney involved, didn't matter. By the way, it also didn't matter, because I'll tell you this in the case, that they went to the state court and got the state court to rule that, and this is the unfortunate part about this one, is it's only the, the trustees and the heirs who are going down there to try to get the court to bless what they've already done. But they got the court to rule, oh, yes, it's ambiguous, and a distribution to charity would be allowed. The tax court didn't follow that because, as they'll often point out, there was no actual adverse party in that hearing where this was determined to be ambiguous. And now they're saying the IRS isn't bound by that, and neither are we. We're determining this under federal law. Therefore, we're saying it wasn't authorized per terms of the trust. Therefore, no current deduction. Now, remember, this is true even though the IRS agreed that the payment really went to a charity and, it was actually made. The payments were actually made. It went to a qualified charitable organization. With a trust, you've got to show that it's authorized under the terms of the trust document, and it's paid out of gross income. Private letter ruling 2016-40-001 is up next. It was issued on September 30th. This is the case of an S corporation that lost its S status. In this case, the S corporation had a resident alien shareholder. Now, a resident alien shareholder is okay because, you can be either a U.S. citizen or you can be a resident of the U.S., but what you cannot be is a non-resident alien. Without telling the S corporation initially, this individual decided to leave the U.S., and he ceased to be a resident alien, became a non-resident alien. The S corporation didn't discover the problem till it came around time to do the tax return, and this shareholder said, oh, I need to change my address, and he gave an address outside the U.S. The S corporation, did their due diligence at that point, discovered we have a problem, and they applied for a private letter ruling request. Now, the IRS agreed to grant the request, though obviously they had to get rid of the non-resident alien shareholder, redeem him out, and they had to make other adjustments. The service wanted to pretend he wasn't really there during the period that he held the shares. And the bad thing too was they had to pay for the ruling. But they did, in this case, get it held as inadvertent. The good news is the IRS very often, in almost all cases, will hold it as inadvertent unless there's some really bad fact. The bad news is you have to get the ruling. Only the IRS can waive this, and they will only waive it via a private letter ruling in almost all cases, because there's going to be not a whole lot of authority except for late elections to allow you to bypass the PLR route. So that means we have to get our ruling. Problem, which I mentioned, it means even if you have this exact fact pattern, you'll get your ruling, you still got to pay for it. So if your S corporations have always got to worry about all the ways they could lose their status because a shareholder is or could become ineligible. If you have somebody who's not a U.S. citizen and is a shareholder, you need to pay very close attention to where they're living. And also you need to make it very clear to them that if they do leave the U.S., we're going to have some sort of redemption program in place to maintain our S status. Next up, Chief Counsel Advice 2016-40-014. This one is on September the 30th, 2016. This is the case of the IRS. In this case, issues a ruling in an area that a lot of us have been discussing for quite a while. Now, standard caveat, this is only a Chief Counsel advice, so it's the IRS's opinion in this case. Does not mean it would be their opinion in every other case. Does not mean they'd win in court if they went down this route. But given some other things we've seen from the service recently, it seems highly likely that this is their position that will most likely be asserted if anybody asked. And we don't know yet how the courts would rule. In this case, a partnership that owned a restaurant, a franchisee restaurant, they had paid their manager, who was also a partner, a reasonable guaranteed payment that they said, and let's assume it represented reasonable compensation for the work he did. Then he got ahead and got flow-through income from the partnership based on, the rest of his interest. So he got a flow-through interest, flow-through income. The partnership treated that flow-through income as not subject to self-employment tax, only the guaranteed payment subject to SE tax. Now, that's a position a lot of people have been discussing for many years about advancing, and it looks at the partnership equivalent, kind of as an equivalent status as an S corporation using the guaranteed payment mechanism. Well, unfortunately for us at this point, the IRS decides that doesn't work. Specifically citing the Reither case from New Mexico from 2012 and the Rankmeyer case, which we all remember from 2011, which is the more general interest, the IRS position was that in this case, the flow-through income all had to be subject to SE tax. They take the position there's no authority for not treating it as SE income. And therefore, because he was actively and materially participating in the enterprise, that all of his income, you can't just divide up a portion, and say, oh, here's a guaranteed payment for reasonable compensation and take it from there. Now, whether this will stand up in court, whole big question. But it does definitely mean that if you've been going this route, you probably need to warn your clients, because what we're seeing is the service appears to be getting, slowly but surely, more aggressive in looking for SE income from partnerships. And this may simply be a warning shot that now they're going to take a look at those guaranteed payment structures and potentially decide that, that doesn't work. Next up, the Ninth Circuit gave us a ruling sustaining the tax court. This is involved in the case of Yeri versus Commissioner. The Ninth Circuit, in case number 14-73914, which was issued on October 13th, affirmed the 2014 decision of the tax court, 143 TC number 7. In this case, the taxpayer had been imposed a penalty for failing to disclose a reportable transaction on his return equal to 75% of the tax reduction from claiming the benefits. Now, remember, it doesn't matter if the benefits would ultimately be allowed on exam. This penalty applies if you don't disclose, regardless of whether you actually win the case of whether those benefits should have been disallowed. Now, what was interesting in this case was after that initial return was filed, the taxpayer later made an amendment to the return, and it reduced his tax to zero even without the benefits of this listed transaction. So the taxpayer, said, wait, it's 75% of the benefit, minimum penalty of $5,000. I should only own $5,000 because this really didn't reduce my taxes for that year by $1. The tax court disagreed, said, sorry, your original return is what counts in this case. Mr. Yeri wasn't happy with that, so he appealed to the Ninth Circuit. And unfortunately for Mr. Yeri, the Ninth Circuit came back with the same answer. In a very short opinion, the Ninth Circuit simply said they agreed with the tax court and effectively said that it would be applied on the original. So looks like, again, 6707A, this is a reported tax court decision, and now we have a court of appeals saying, you know what, the tax court got this right. Next up, finally, we have a notice here. As most of you are aware, Hurricane Matthew caused a lot of damage and continues to cause a lot of damage, the flooding following Hurricane Matthew in North Carolina. In news release IR 2016-19 issued on October the 11th and being continually updated. In fact, there was an update to it this morning on the 17th of October. The IRS has provided for relief from individuals in affected counties in North Carolina. That list of counties is continually being updated. It delays most tax obligations. If individuals have a tax obligation that arose on or after October 4th, when Matthew arrived, that obligation in many cases is delayed. They will not have to do it until March 17th of next year. That will include actually obligations for due dates of returns for most returns. It will include also the estimated tax payment due in January. It can be made as late as next March. Now, failure to deposit penalties don't get that long of a break, but for those that were due on or after October the 4th, as long as you make the deposit by October 19th, if you're in an affected count, if you're an affected taxpayer, you'll be able to get out of the failure to deposit penalties. The announcement indicates that the IRS is going to attempt to identify potentially affected taxpayers, but if they don't properly identify you and you get a penalty, they give you information in this news release about how to get out of that penalty. The IRS also notes that this is not just for people that live in those counties. It would include people that have businesses in those counties, people whose records, they need for their taxes were located in those counties, and people coming in to do relief for those counties, as well as individuals who may have been affected due to deaths of related parties in those counties from Hurricane Matthew. So all of these are involved in this particular relief provision. So if you have somebody who's potentially affected by that, you want to get this IR 2016-19. I do have up on the website as of today a list of all the affected counties that we had as of the 17th. Again, keep an eye on that notice because it is potential it could still expand some more. And if it does, you want to make sure you get that off the website. Well, hey, filing season's over. So now's the time to really step up and decide, get your continuing education. So be sure to go check your state society's list of courses here for the last part of this year, because this is the big CPE season, and sign up for some state society CPE. Again, we've got a number of good 8-hour courses. Most state societies also tend to have a lot of their tax conferences this time of year. So you might want to check to see if there's something coming up on a tax conference you want to go to and see. And check, obviously, take a look for those courses that we're offering here at Nichols Patrick. This has been the current federal tax developments for the week of October the 17th, 2016. Be sure to check online at currentfederaltaxdevelopments.com. There you can download a PDF of the articles on today's podcast, information from that. You can send any comments you might have to Ed Zollers at currentfederaltaxdevelopments.com, or you can follow me on Twitter at Ed Zollers. Well, hopefully at this point, since my filing season now is finished up, we'll be able to keep everything up to speed now and up to date, so I won't fall behind and have to miss another podcast. And so be sure to be watching and be sure to join us here a week from today when we'll go ahead and go with the next weekly update here on current federal tax developments.